Hi, this is Attorney Matt Benedict. Thanks for watching. This is Driver's License Restoration Appeal to Circuit Court, a basic evaluation in Michigan. This video is for the person that has already held a hearing in front of the Secretary of State and the Secretary of State did not reinstate their license. I want to provide the viewer with an idea of what facts and circumstances may warrant involving an attorney in their appeal. The following are some of the circumstances and events that I look at when I am reviewing a client's opinion order for appeal. Before I get into the substance of this video, I'd like to remind the viewer that the best strategy for getting your license back in Michigan is to hire an attorney to represent you at the Secretary of State hearing. The reason it's so important to hire an attorney for the initial Secretary of State hearing is that, number one, there's a very good chance that with enough preparation you can be awarded a driver's license from the Secretary of State in the initial hearing. And number two, as for appeal, the petitioner that hires an attorney for the Secretary of State hearing is far more likely to have developed a case that touches on all the essential elements for restoring your driver's license. Once this happens, the appeal to the circuit court will become easier and more successful. In this slide, I provide the grounds in which an appeal may be brought to circuit court. Not every hearing before the Secretary of State results in an error that will permit an appeal. For a driver's license restoration case, an appeal must be filed in the circuit court within 63 days of the hearing. Now I'm going to get into some of the areas and ideas that I look for when I'm trying to determine if a petitioner has a good case for an appeal to the circuit court. The rules for the Secretary of State require them to find that the petitioner had sobriety for over a year. In this situation, at the hearing, the petitioner did demonstrate that they've been sober for over a year, and they had the evidence to corroborate their abstinence from alcohol. The witness letters have to state that they have been around the petitioner when there's been alcohol consumed and petitioner, she doesn't drink. In this slide, I'm talking about stating conclusions without backing it up with facts or testimony from the hearing. And when I see this, it begs the question, do they even have a transcript to reference, or did the hearing examiner make up their mind almost immediately? In this slide, I'm talking about the hostile hearing examiner, and I've blogged about this at length, that the hearing examiner's job isn't necessarily to give you a license, and sometimes at the hearing you can almost sense that they have become frustrated and or angry with the petitioner. When this happens, the hearing examiner is more likely to run afoul of their affirmative duty to assist the petitioner. Some other signs that the hearing examiner is not following their affirmative duty to assist the petitioner would include the very short hearing, and I've even heard in the past that they will flat out state that they don't have much time. In this slide, I am talking about the situation where petitioner goes to order a transcript from the Secretary of State, AHS, and then they are informed there is no transcript available. There is also the rare situation where the petitioner was never diagnosed as drug and alcohol dependent. When this happens, the more stringent Rule 13, wouldn't apply at the hearing. The customary evidence of having a support group or other means to deal with an addiction would not be all that important in this case. But like I said in the slide, this situation is very rare. And finally, in this slide, I'm talking about when an appeal is not viable. And the first thing I talk about is when there's testimony that the petitioner occasionally has a drink of alcohol, or they attend a bar every once in a while. Either of those facts, either from the petitioner or a witness, will sink any chance of obtaining a license during an appeal. The second sign that an appeal will fail is that when you look at the witnesses that were discussed in the hearing, none of them talked about the petitioner's abstinence from alcohol. And when this happens, a major element of what has to be proven at the hearing is just not supported by the evidence. In this slide, I'm talking about the next step, which would be to have an attorney read your opinion and then talk to you about ordering a transcript to further investigate what happened at the hearing, or file an appeal without the transcript. Often it's necessary to file an appeal before you have a chance to read the transcript because of the time constraints, 63 days in which to file the appeal. Not all attorneys are created equal. A lot of times you'll come across an attorney that will suggest that the client should hire them and they should immediately file an appeal. This should never be done until the attorney reads the order first.